Bless you.
Oh, Lord.
Mute people.
Good evening. This is the House Judiciary Committee. It is the 5th of March, 2021. We have a voting session this evening for House Bill 670, the bill from the Speaker for police reform. We are going to begin. There are a number of amendments to the bill, and we're going to begin by moving the amendments that were approved by the Public Safety Subcommittee onto the bill. And for that, I recognize Vice Chair and Subcommittee Chair.
Thank you, Mr. Chair. I move the bill as amended by the Public Safety Subcommittee.
And do you move the amendments first to, we move the amendments first from you're moving the
Yes.
amendments, right? Okay. So the motion is on the amendments that the subcommittee approved.
Second.
And a second from Delegate Deborah Davis. That's fine. All right. All in favor of the amendments that the subcommittee approved, please say aye.
Aye.
All opposed,
Aye.
no. There are no votes being registered. So here's how we're going to do this. I believe that if you go to the bottom of your screen, we're going to try this. Oh no, that won't work. So we can't do it that way. Never mind. We will, I don't necessarily mean to do a roll call every single time, but we need to do these amendments before we get to any other amendments. So all in favor of the subcommittee's amendments, please raise your hand now. I see Delegate Fisher, Lopez, Davis, Shetty, Moon, the Vice Chair, Anderson, Watson, Bartlett, Williams, Jones, Crutchfield, Conaway, and Cham for 14. So those amendments are approved. The subcommittee's amendments are approved. We'll now go to amendments on the bill, and there are several that we'll go to first. First, in your packet on page 1 is the first of 2 amendments from the chair, and it seeks to address an issue from Delegate Anderson, who wished to have a definition of exigent circumstances and said that he wanted to have the Supreme Court's definition in the bill. So to that end, this amendment would do just that. It would say that exigent circumstances retains its judicially determined meaning, and that would mean that whatever the definition of the Supreme Court, that would be the definition of exigent circumstances. Is there any debate or discussion regarding this amendment?
Move the amendment.
It's a motion on the amendment. Is there a second?
Second.
And a second. All right, Delegate Arakan with a question.
Thanks, Mr. Chair. Can you just read what the Supreme Court's actual definition is, not just the acceptance of a definition? I don't know what it is.
I'm going to go to Claire, and if we need to pull down, basically what the amendment would do, as I said, it would say whatever the Supreme Court's existing law is. I think that they talked about this in the subcommittee, if I'm not mistaken. But I'm going to ask counsel if she has that information. If she doesn't have that information handy, then we can come back to this one.
Well, it's developed in case law. It's not, there's no necessarily a concise definition that the Supreme Court has given. It's basically, sorry, I'm trying to get to my computer. I'm having trouble with the screen. It's basically an emergency situation, and there were various cases over the years, starting in, I believe, the 1960s, in which a particular fact situation was presented, and the court said, yes, that is exigent circumstances, or no, that isn't. It's kind of a fact by fact, circumstance by circumstance determination.
Okay, thanks.
Are there other questions? Delegate Cox?
Thank you, Mr. Chair. Have we received a response from the judiciary about including case law definitions in the bill on this particular issue?
I'm familiar that we have in other pieces of legislation, at least during my time here, we have consistently and said that certain terms retain their judicially determined meaning. I think that was one of the, we've had that, and I think that was in the juvenile interrogation bill. I have not heard anything from the judiciary, and it is not unusual for us to define a term by its judicially determined meaning.
Okay, thank you.
The reason for that is if you set the meaning now and then the Supreme Court changes the meaning down the road, then you have a conflict between the law and the Supreme Court, and that causes problems down the road.
Sure thing.
Delegate McComas.
Thank you, Mr. Chair. Just, I know that a lot of these things, as far as exigent circumstances, they teach as far as for the folks becoming police officers, as well as probably for the judges as well. So basically, if this, in other words, by saying it's exigent circumstances, the police, the judiciary, everybody's kind of going to be on the same page because they've all kind of been instructed as far as what the case law is by the Supreme Court defining it, you know, even though it is a case-by-case basis. I mean, is that fair to say that keeping it that way, we don't have to define exigent circumstances in the bill?
Right. I mean, that's correct. You don't have to define it in the bill. And then what we end up having is the training that is also stipulated in this bill would track whatever that definition is over.
Okay.
All right. We have a motion and a second on the amendment. All in favor of the amendment, please raise your hands and I will go through. All in favor of the amendment, please raise your hands. Anderson, Shetty, then they moved. Okay. Actually, we'll do raising physical hands because it makes it a little easier. It won't move around on my screen so much. All right. Anderson, Shetty, Davis, Lopez, Watson, Moon, Erican, Atterbury, McComas, Griffith, Bartlett, Williams, Grammer, Cox, Fisher, Jones, Malone, Crutchfield, Conaway, and Cham. All right, that's unanimous. So that amendment is adopted. All right, we'll go now to the second of my amendments. This addresses an issue that came up in our discussion last night, and it has to do with the physical assessment that the police officers need to do every year. And it adds a couple words. The current language, which lives on, well, in my copy of the bill, it's page 20. I'll go to the section. That's probably easier. It's 3209E. The full text, as it is right now before this amendment, as a condition of certification, a police officer shall annually submit to a mental health assessment and a physical agility assessment to establish continuing fitness to carry out the duties of a police officer. The amendment that I'm offering would change that, and for the second clause that starts, and a physical agility assessment to establish continuing fitness to carry out their assigned duties as a police officer. This seeks to address the issue that Delegate Malone raised last night about some officers who may have sustained injuries. They're on desk duty, so they don't go out. They don't go out on patrol. The vice chair included this because of concerns about people who were going out on patrol and wanting to make sure that they were physically able to go out and patrol, because the larger concern is people were more likely to use force if they didn't have the physical means to keep up. And I'm kind of shorthanding what the vice chair was saying. Are there questions about this amendment? First, can I have a motion on the amendment?
Move the amendment.
Is there a second?
Second.
All right. Any further discussion? Seeing done, all in favor of the amendment, raise your physical hands. Delegates Lopez, Davis, Shetty, Anderson, Watson, Moon, Arakan, Atterbury, McComas, Griffith, Bartlett, Williams, Grammer, Cox, Fisher, Rachel Jones, Malone, Crutchfield, Conaway, and Chan. That's unanimous, and that amendment is approved. Okay, now we're going to go to Juanica Fisher. This is amendment 923121/1. I'm going to go to this amendment, and this has to do with the pensions of police officers. Delegate Fisher, would you like to talk about what this amendment does, please?
Yes, Mr. Chair. Sorry, it took me a second to unmute myself. This amendment would, if a police officer is found guilty in court and exhausts all appeal options. So, maybe they plead guilty in district court and they plead to that and they don't appeal, or they do appeal and they're eventually found guilty after all options in our judiciary system, that their pension can be taken from their eligibility for that. Further in the amendment goes into the fact that what they paid into it, you cannot actually take. So if they were paying $50 a month into the pension, they would get that $50 that they paid out of their salary. But if it was a matching fund, there are different things like that. The local state's attorney or the attorney general can file the proper paperwork to obtain that remaining pension and or the victims, depending on the case. So that's basically the amendment.
Move the amendment.
Is that okay, Mr. Chair?
Delegate Fisher, hold on. Well, let's do that. Let's move the amendment. There was a motion for the amendment. Is there a second? Okay.
Second.
So discussion on the amendment. Delegate Fisher, is this for any conviction, for any crime, or are there specific crimes that?
Oh, sorry, I forgot that important point, Mr. Chair. It's for specific crimes that were outlined in other portions of the bill. Obviously, falsifying evidence, obviously a violation on use of force, and not use of force on. I'm sorry, on.
I think Delegate.
I'm not remembering my right verb.
You're all right. It's on page 6 of the amendment packet, which is it's page 3 of the amendments, page 6 of the amendment.
And it outlines all the eligible.
Yeah. So it's a felony.
It's not for anything.
It's a felony or perjury or another misdemeanor relating to truthfulness and veracity.
Yes.
Okay. All right. Are there questions, further questions for this amendment? All right. Seeing none. All in favor of this amendment, please raise your hands. Delegates Lopez, Davis, Shetty, Anderson, Watson, Moon. The Vice Chair, Bartlett, Williams, Conaway, Crutchfield, Jones, Fisher, Cham. For 14, the amendment passes. Okay, we will go now to Delegate Griffith's amendment, which is on page 10 of the amendment packet. And I'll just read it. Actually, can you put it on the screen, Dylan? But I'll read it while he's doing that. A police officer who was suspended without pay, this goes under the part of the bill where they can be suspended by the chief, on a charge after having been charged for something. If they were suspended without pay under this subsection, this officer is entitled to receive back pay if an administrative charging committee determines not to administratively charge the police officer in connection with the matter on which the suspension was based. And we can all read the rest of it, and I don't need to keep reading. Is there a motion on this amendment?
Move the amendment.
It's a motion for the amendment. Is there a second?
Second.
All right. Moved and seconded. We'll have discussion on this amendment. Is there anyone who'd like to ask questions or has a comment on this amendment? All right. Seeing none, we will call a vote here. Please raise your hands if you are in favor of this amendment. Delegates Lopez, Davis, Shetty, Anderson, Watson, Moon, Arakan, the vice chair, McComas, Griffith, Bartlett, Williams, Grammer, Cox, Conaway, Crutchfield, Malone, Rachel Jones, Wanika Fisher, Cham. That motion is, that amendment is adopted. Okay, we're going to go now to page 12. This is from Delegate Moon. Delegate Moon, are you able to tell us a little bit more about what your amendment does?
Sure. This one's pretty simple. It adds a provision requiring police officers to identify themselves during traffic or other stops. Again, this is absent exigent circumstances. And the reason we're putting it in here is it came from a bill from Delegate C.T. Wilson and Senator Charles Sidnor, HB 197 and SB 589, that would have required police to state their reason for stopping you and protect your rights to tape police encounters. But we forgot this one little piece. It also requires them to say who they are. So that's all it does. I move the amendment.
Second.
The motion on the amendment is a second. Is there further discussion on this amendment? Seeing none. All those in favor of this amendment, please raise your hands physically. It's Lopez, Davis, Shetty, Anderson, Watson, Moon, Atterbury, Bartlett, Williams, Wanika Fisher, Rachel Jones, Crutchfield, Conaway, and Cham. All right, the motion passes. All right, now we're going to go to a new amendment, or not a new amendment, another amendment, I should say. And this is the one that begins on page 13. I have worked, and Delegate Barron has put in a lot of work on this amendment. This amendment is effectively the third reading version of House Bill 6, or I should say of the Senate bill, I think is Anton's Law in the Senate. And it's got some differences, but so I'm going to just run through it really quickly. Well, not that quickly. I'll run through it carefully and describe what it does to the committee. This has to do with the public's availability or public accessibility to police misconduct files. The first part of the amendment reflects language that was created in the Judicial Proceedings Committee related to a technical infraction. The idea would be that a technical infraction would still be a personnel record and would not be accessible under the PIA. If you move to page 14, there is a process by which there's a PIA board. They would receive, review, and resolve complaints filed from a custodian alleging that an applicant was acting in bad faith or was filing frivolous complaints for a police officer's records. They'd have to issue a written decision and then make a decision as to whether the information should be released or not. That part, the part with a review by the board, I don't believe that is not in the Senate version of the bill. On page 15, we add in that a custodian shall allow inspection by the U.S. Attorney, the Attorney General, the state prosecutor, or a state's attorney. Those offices are added in the House bill in 671, and we're bringing that over to this bill. in section C, it says that except as provided in the next paragraph, which says that a technical infraction is a personnel record for purposes of the section. It says that a record relating to an administrative or criminal investigation of misconduct by a law enforcement officer, including an internal affairs investigatory record, a hearing record, and records relating to a disciplinary decision, is not a personnel record for purposes of the Public Information Act, meaning that people can request the record through the custodian of records. And the custodian of records then has to make a decision as to whether or not it would be released. On page 16, it continues records relating to an administrative or criminal investigation of misconduct by a law enforcement officer, including an internal affairs record, a hearing record, and records relating to a disciplinary decision. Again, that's a continuation of the last section. Again, it talks about how they're available to the U.S. Attorney, to the Attorney General, State Prosecutor, and State's Attorney. There are reasons that the custodian can deny inspection, and you can see them in the middle of page 16. It's existing law because they could deny inspection because they would interfere with a valid and proper law enforcement proceeding, deprive another person of a right to a fair trial or an impartial adjudication, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose an investigative technique or procedure, prejudice an investigation, or endanger the life or physical safety of an individual. There are some other things that the custodian would have to redact. The custodian shall deny inspection of a record if the record relates to an active investigation or to the extent that the record reflects medical information, personal contact information of the person of interest, information relating to the family of a person of interest, or witness information. So in other words, if there's personal information like a person's address, their phone number, their social security number, things like that would be redacted from these documents. If somebody requests the information, the person about whom the record was about, so the officer in question would get a notice that that information was being requested, but it wouldn't say who was requesting the information. Further, the police records in the bill under 3113 could not be expunged or destroyed destroyed by a law enforcement agency. And then after that, in 3514, there is the creation of a reporting of the number of times that there of aggregate numbers of cases that were administratively charged, not charged, unfounded, and exonerated. So the amendment as a whole seeks to bring in, if really in substance, the third reading version of the PIA bill that was passed in the Senate. And it makes some changes that would seek to redact some personal information and some other issues that I've just laid out already. First, could I have a motion on the amendment, please? And then we'll take discussion. Could I have a motion, please, on the amendment?
Move the amendment.
All right, is there a second and a second? All right, it's fine. We have questions, so we're going to start with Delegate Moon.
Sorry, so I just want to understand this amendment clearly. When you say the third reader version of the law, this amendment allows for unsustained records to be released to the public?
That is what this would do, yes.
Okay, and it further says that these records cannot be expunged, and I assume that's a difference between what the Senate did and what we're trying here.
That's also true. The Senate, I think if I read the Senate bill correctly, actually it was one of the Senate bills that passed, would allow for expungement after 3 years.
After 3 years, okay. And then lastly, so the only caveat you said is identifying information and technical infractions. And can you just clarify what a technical infraction is?
And I'll go back to that definition. Rather read the definition than try and do everything from memory. Technical
Sorry.
infraction means a minor rule violation by an individual solely related to the enforcement of administrative rules that, one, does not involve an interaction between a member of the public and the individual. Two, does not relate to the individual's investigative, enforcement, training, supervision, or reporting responsibilities. And three, is not otherwise a matter of public concern.
So this is sort of like I took too long a lunch break kind of thing.
My badge was not shined properly. My socks weren't pulled up.
Okay, thank you.
Relatively minor. Delegate Cox has a question.
Thank you, Mr. Chair. And to clarify, the investigatory records that cannot be expunged, I think I heard you say that that would include unsustained records, which then may be released to the public. Is there any, I thought that this was, had accepted some guidelines for, so that we don't end up with these records on the internet per se.
So what the amendment says is that a record relating to an administrative or criminal investigation of misconduct by a police officer, including an internal affairs investigatory record, a hearing record, and records relating to a disciplinary decision may not be either expunged or destroyed by a law enforcement agency.
And my concern then is you're going to have unsustained records then released to the public. I thought there was a protection in there that they could not be, I thought there was an accepted amendment that would give some guidelines as to who could access those unsustained records.
So in the bill, but it's also in existing law. Again, on page 16, section B, there are 7 reasons why a custodian can deny inspection by a person in interest, and those are listed there. And that includes with interfering with a law enforcement proceeding, depriving another person of a right to fair trial, and I'm not going to read them all again. So there are those reasons. The custodian of records also, and this is where I was leading off and includes, this is on the top of 14, they could, you get a review by the PIA board, the custodian can just determine that if there is a pattern of requests that are frivolous, vexatious, or in bad faith, that then that person who is making the request disagrees with, they have an appeal process to be able to go up, but that they have at least that. They have, yeah.
And
So
that
that is in there. That is in there, but you know, I think the bigger deal a little bit as to controlling some of the information is that the not just the officer's personal information, but also the victim's personal information, the witness's personal information would be redacted and allowed to be kept apart. Okay.
And I have an ongoing concern about allowing even persons of interest to widely disseminate that improperly. So I'll have an amendment later, but thank you.
And we'll take that up. I think we have to get through this to get to that. So we'll.
Thank you, Mr. Chair.
Are there further questions regarding this amendment? All right, seeing none, we will take a vote on this amendment, and because I think it needs to, I think we'll do the hand raising again. All in favor of this amendment, again, yeah, this is the Delegate Barron amendment. All in favor, please raise your hands. Delegates Moon, Lopez, Davis, the Vice Chair, Anderson, Shetty, Watson, Bartlett, Williams, Fisher, Jones, Crutchfield, Conaway, and Cardin. That's 14. The amendment is adopted. All right. The Okay, we're going to go to the speaker's amendment on page 19. Page 19, this addresses an issue related to when officers can be interrogated and when they can be interrogated with and the time frame in which they can be interrogated. I think the vice chair, can you speak to this a little bit? Madam Vice Chair, you're on mute.
Sorry, I did that because I was printing stuff out and I didn't want you guys to hear my printer. So yes, this speaker's amendment basically says a police officer may be required to submit to a blood alcohol test, breath, urine, and the like, a polygraph during the investigation. If they are required and they refuse, then the law enforcement agency can commence an action against them, which can lead to punitive disciplinary measures for that refusal. And they have to submit to an interrogation.
I think this addresses a self-incrimination issue that was in the bill where we had the right, requirement for police officers to be to cooperate with an interrogation.
But they're not, I forgot to say the main thing, sorry.
Yeah.
This is all not admissible in a criminal action.
Correct. Right. So
Which is essentially what we're fixing.
We're fixing the self-incrimination issue with the interrogation process. All right. Can I have a motion for the amendment?
Move the amendment.
Is there a second?
Second.
All right. Motion and a second. We have questions. We'll go to Delegate Eric.
Thanks. So I just want to make sure I understand what the vice chair was explaining. So this is going to allow for, if there's any type of investigation, for the chief to compel them to tell them information. But then any information is not, because it was compelled, can't be used in a court of law. Is that?
I mean, they can't use, and this is current law. Anything that they to some degree it's current law, but they can't use anything that is a compelled statement. They can use it in a personnel matter, but they can't use it in a criminal matter because that would violate self-incrimination.
Okay.
This clarifies that within the bill.
And so in our pretty flow chart that we have, where does
Very pleased you think it's pretty.
It's beautiful. I'm so proud of Matt. He did a great job. So in that flow chart, where in the flow chart can this compelled statement then be used? Or
the compelled statement can be used in the personnel matter. It just can't be used in the criminal matter. It couldn't be used in a criminal matter no matter what, because it's compelled.
So, okay. So like the trial board situation, the charging committee and trial board line of the flow
Yes.
chart,
Right.
but not the investigative agency line.
Not in a criminal investigation. So you could not use that compelled statement in the charge if there was a police officer who was charged with first-degree assault because they hit somebody with a baseball bat. You could not, and it was during the line of duty. You could not use a statement that was compelled through this process in the criminal case that the state's attorney is bringing against that officer, because that would violate their rights against self-incrimination.
And that process is now going to be handled through the independent investigative agency.
If it
Piece.
involves, yes.
Okay. Okay.
right.
Thank you.
Delegate Cox, then McComas.
Could the vice chair just run through those things that can be compelled, and if the officer refuses, the officer can be disciplined, and what the extent of discipline is?
Yes, so make sure I'm not muted. Okay.
Thank you, Madam Vice Chair.
So it does specifically say to Delegate Erican's question and the chair's point, it specifically does say in connection with a disciplinary matter. So to make it clear that it's not criminal. An officer may be required to, 1, submit to blood alcohol test, 2, blood, breath, or urine test for controlled dangerous substances, 3, polygraph examinations, and last, or interrogations that specifically relate to the subject matter of the investigation. And then if the officer is required to submit to an examination or interrogation and refuses, the law enforcement agency can begin an action that may lead to a punitive measure as a result of the refusal. So it's up to them to determine what that punitive measure would be.
So my concern is on the amendment, Mr. Chair. My concern is that, with all respect to the speaker, who I know has worked so hard on this bill, but this I think goes too far, because I don't think anybody on this committee would agree that we could subject innocent until proven guilty arrestees, people who the police arrest, subject them to polygraph exams, interrogations, forced submissions to tests, and if they refuse, to then discipline them professionally. I mean, that to me is an outrage. I think it goes too far, Madam Chair, Madam Vice Chair, and I would firmly oppose this amendment.
Delegate McComas, then Delegate Juanita Fisher.
I just have a question. Could these things, they would not be used in a criminal case, I understand, but is there any way that, let's say the subject matter was that the guy had a drinking problem or a drug or alcohol problem and there was domestic violence, wife wants to get a divorce, is there any way that these records could be pulled into a civil domestic case? Could we just put that they can't use it for a criminal or a civil case? That in other words, it can only be used for the, for the purpose that they need for the investigation, but it can't be used for any other type of case.
First of all, it says in the amendment, and Dylan, if you could please put up the amendment on the screen. It says in the amendment first that this is in connection with a disciplinary matter. So they can be compelled be compelled in connection with a disciplinary matter. And for what it's worth, that's effectively current law now under the LEOBR, that they can be compelled to testify from people who have been on the committee for some period of time. That going back, and people talk about why are people well, I'll skip one thing, but let me go to that's been the law. It is the law because it is only within the disciplinary matter that these items are used. I mean, could they use it in another matter? I don't think they certainly couldn't use it in a criminal matter.
Well, yeah, right.
Law matter. I'm kind of straining to think how that necessarily maybe be relevant if it were an issue related, I don't know, maybe custody. I don't know. But I frankly, again, the reason for this amendment is to fix a problem in the bill to make sure that the language that is in the bill that compels testimony, that it makes it clear that it's only in a disciplinary matter and it's not at any stage in the process that could impact their Fifth Amendment rights against self-incrimination.
Okay, all right.
Go to Delegate Juanita Fisher.
I am unmuted. I just wanted to respond on behalf of Delegate Cox's concerns. I wanted to add to that one, I've seen not only my clients, but regular citizens go through questioning and intimidation and all kinds of things. And I will say that the police have public trust, which puts them in a different posture than your average person who's being investigated. So I think that is appropriate for this amendment, and I would be in favor of the amendment. Thank you, Mr. Chair.
Anything further? Delegate Cox's hand still raised, so go ahead, Delegate Cox.
Thank you, Mr. Chair. And I respect that this is probably an attempt to have a good faith a boundary set, but I think it's still outrageous in the context that when you look at the fact that police officers are the only ones, as you mentioned, Mr. Chair, that are able to be compelled right now to give a statement. And that presently, to my understanding and my work, has been a very narrow scope and a limited to a written statement, signed written statement. And it's very strong rules against that. But even that is something that we require that is far beyond. I mean, we can't do that to a criminal defendant. And yet we're trying to do this to the police who are trying to protect our families. I just think when you add all of these things together, it just is going to take the average officer and think, my gosh, I mean, here we are, trying to defend people, and now we're going to be subjected to polygraphs, interrogations. I mean, there's no limit. So that's my concern. But thank you, Mr. Chair.
I appreciate that, Delegate Cox, but it's also effectively current law. Are there further questions or statements on this amendment? All right, if we could take down the amendment so that I can count hands. If you are in favor of this amendment from the speaker, please raise your hand. Delegates Fisher, Arakan, McComas, Moon, Lopez, Davis, Shetty, Anderson, Williams, Bartlett, Watson, Atterbury, Grammer, Conaway, Crutchfield, Rachel Jones, Cham, and Cardin. I think that was 17. And with that, that amendment is passed. All right.
Mr. Chair, may I be registered as a no?
And you were registered as a no, and I did see, I think it was Delegate Malone's hand. I don't recall seeing Cox, and Delegate Griffith were no's. Yeah, and Malone.
Mr. Chairman, I'd like to change mine to a yes, please.
Delegate Griffith votes yes on the amendment. Doesn't change the outcome. Okay. There are 3 other amendments that have been offered. One is Delegate Cox, well, another is Delegate Grammer, and a third is Delegate Malone's. Actually, there are 4. Delegate Cox has 2 amendments. So what we'll do is we're going to start with Delegate Cox's amendment. I'll ask him if he wants to press it. And this goes to bias. This goes to page 9.
Mr. Chair, I'm withdrawing that amendment.
You're withdrawing that amendment? Okay, we won't do that one. Then let's hear your PIA amendment. So this is 913-329/1.
Yes, thank you, Mr. Chair. And
Go ahead.
Thank you, Mr. Chair, and honorable members of the committee. Again, this is a approach to just provide safeguards to the information that we are now going to be allowing a greater number of people to have direct access to. Personal information of the law enforcement officers in your community needs to be protected at least as much as we protect anyone else who has confidential records. They deserve that respect. And so what this does is simply add in the language that already exists in the law regarding confidential state records, such as DSS records, and says that anyone who is unauthorized to obtain those files, and it says, and I'll read it, it goes straight to the 4-402 of the general article, but it says no one may disclose a personnel record only to anyone other than those authorized to inspect the personnel record under the subtitle 3, and that anyone who does so in violation of the law will then be subject to a misdemeanor upon conviction, 3 years in jail and a $5,000 fine. So presently, my understanding is with all of these new extensions of information, the officers are potentially going to be subject to information being distributed on the internet by unlawfully by third parties. And all this does is simply say, you know what, that we're going to continue our confidentiality protections as to this information, and we're going to make it a misdemeanor. So with that, Mr. Chair, I would press the amendment.
Second.
Are there people who have questions regarding the amendment? The Vice Chair?
Thank you, Mr. Chair. So I may have missed it, but I'm looking at the amendment, and at the very beginning, it says, and I don't think Delegate Cox said this, before a person who is authorized to inspect a personnel record of the section, the person shall file with the custodian an affidavit under oath. And I think that the work group, and actually going back to 2016, was moving away from barriers such as notaries and affidavits and signing things under oath, because the whole purpose was to make records more available and transparent to the public. So I think this is a barrier to the process. So I would urge the committee to reject this amendment. Thank you, Mr. Chair.
Mr. Chair.
Delegate Cox?
Thank you, Mr. Chair. And Madam Vice Chair, thank you for pointing that out. I didn't intend to skip over that part. The requirement presently in the law is that whenever you transfer custody of records that are confidential, such as DSS records, you have to disclose to that person that if they were to disclose it to a third party, that that's a crime. And that in this case, signing the affidavit is simply attesting that they are the authorized person under law to receive those records, and that they have then they have received that notice that is part of the requirement under Section 2, that they understand that any disclosure of the personnel record is in violation of the title is subject to the penalties under 4-402. So it's providing that notice to the party who is authorized to receive the records, that first of all, that they are attesting that they have the legal right to this file. And then secondly, that they are affirming that they will not disclose these records to an unauthorized party.
Delegate Moon?
This might be a question, but it sounds to me like this amendment would perhaps obstruct the press from writing about findings of misconduct, unless I'm missing something, and that would seem problematic.
No, actually, this is strictly as to personnel records that may not be disclosed except to authorized persons. So if there's a matter of public record and if there's information that's outside of the statute's intent, of course, the press would have access to that. Or if the press becomes a person of interest, obviously they would have access to that.
Are there further questions or comments regarding the amendment? All right, seeing none. Delegate Cox, do you wish to press your amendment?
Yes, Mr. Chair, because we're talking about husbands and wives and children at stake in our state. I mean, we understand that this is a major piece of legislation that this committee is passing out into the new brave world of this police reform venue. And one of the things that we have to make clear to our law enforcement is that we are going to ensure that they are protected. And if there's no mechanism in the law, Mr. Chair, to ensure that their private information is protected, then the law really has no teeth. So that's really the interest, and I would press the amendment. Thank you.
All right. Well, there was a motion and a second on the amendment. We'll take a vote on the amendment. All those in favor of the amendment, please raise your hands. Cox, McComas, Arakan, Griffith, Malone, Grammer, and Cham. All those opposed, please raise your hands. Moon, Fisher, Lopez, Davis, Shetty, Watson, Atterbury, Bartlett, Williams, Conaway, Crutchfield, Rachel Jones, and Cardin. The amendment fails. The amendment fails 7-13. All right. We'll go now. There is an amendment from Delegate Malone. Delegate Malone, do you still wish to press your amendment on 833-826?
I do, but it's significantly more limited. This amendment was originally brought based upon an earlier draft in which what old page 15 said serious injury has the meaning stated in section 3203 of the criminal law article. But when you go to 3203, the definition there is serious physical injury. We've now struck all the places except for, if you look at my amendment, where it said page 16, line 31, that's actually now page 28, line 31. And where it was page 18, line 5, that's now page 32, line 5. And the purpose of this just was to have it, make sure it's consistent with the criminal law article. So I would ask for just in those two locations, for it to be stated as serious physical injury.
So in the one place in the bill, it would, the current language of the sentence there on lines 30 and 31, on page 28 of the reprint, it says less lethal weapon means a weapon that is expected to create less risk of causing, right now it reads serious injury or death. With the amendment, it would say serious physical injury or death. In the other location, it would say a police officer shall, the current language says, undergo training on enforcement options that are less likely to cause death or serious injury. That's the current language. This would change it to less likely to cause death or serious physical injury. So basically in both places, the first place in the definition of less lethal weapon, the other in the training that an officer has to undergo, it would just add physical in both of those places and make it consistent.
That's correct. That's the definition the work group was using, and therefore, after our many months of effort to have that continue and be consistent.
Right. Is there a second on the motion?
Second.
All right. Are there questions regarding this motion? Delegate Bartlett?
Just one question, and it might be somewhere else in the bill, but if I witnessed a police officer using lethal force on a family member, does this bill allow me to have any type of, obviously the family member who was injured falls in the serious physical, but is there anything with putting in serious physical that would limit me as a bystander who witnessed this damage? So if for instance, if the police officer happened to say, something to show that he was doing something to injure a family member in a way to hurt me and my family member, but only my family member suffered the physical, I suffered the mental injury. Does this change my ability as a family member to make a claim against that police officer?
I don't think
No,
this amendment changes that.
No.
Okay.
On the amendment, I don't think the amendment would address that issue at all. I think this just goes to a definition, and it goes to the training that officers receive.
Okay. I just wanted to make sure when we put in physical that it doesn't do anything to harm the mental injury or the mental damage. Okay.
I mean, I'm happy to hear from anyone if they believe that to be true. All right, are there further comments or questions? There is a motion and a second. Seeing none, we'll take a vote on this amendment. All those in favor of the amendment raise your hands. Cox, oops, my pen has to work. Cox, McComas, Arakan, Griffith, Grammer, Malone, Cham. All opposed, please raise your hands. If you're opposed, please raise your hands. Delegates Moon, Bartlett, Fisher, Lopez, Davis, Shetty, the Vice Chair, Watson, Williams, Conaway, Crutchfield, Rachel Jones, Cardin. 7.
Did you say Anderson?
Did I see Anderson? Oh, Anderson, sorry, missed Anderson for 14. Okay. We're now, the final amendment that was submitted was Delegate Grammer's. It's on page 9 of the packet, I think. 9, 3236271. Delegate Grammer.
Thank you, Mr. Chair. This amendment discontinues the use of no-knock warrants. To explain why I'm putting this forward, frankly, as a conservative and as a gun owner, I increasingly fear for my safety and the safety of my family. Specifically, I feel that gun owners and conservatives are illegitimately targeted in a lot of cases by no-knock warrants. If you compare the Breonna Taylor situation to the Duncan Lemp situation, Breonna Taylor actually, the warrant that was issued was a no-knock warrant, but the warrant that was executed was not a no-knock warrant. Duncan Lemp was killed less than 24 hours before Breonna Taylor got a national movement, and Duncan Lemp's family reached out to all of their representatives in Montgomery County, and they were completely ignored. I think the execution of these warrants is increasingly political. We are seeing more and more of the issuance of warrants for laws that criminalize gun ownership, completely nonviolent offenses that a lot of people don't agree with politically. I don't think that no-knock warrants make the execution of warrants more safe. In fact, if you look at these cases, I think they escalate the situation. And no-knock warrants, in a lot of these cases, can easily escalate nonviolent situations into deadly situations for either the occupant or the officer. I think people have a right to respond, and I think with this amendment, we protect both officers and innocent folks. So with that, I would ask for a second. I'd ask for your support, and I'll move the amendment.
Is there a second? Hearing no second, the amendment fails for the lack of a second. All right, that's the last amendment that we have.
What about Griffith?
Sorry, I didn't hear. No, we did Griffith. We did Griffith's amendment. We've done all of the amendments in the packet. And now we are on the bill. Could I have a motion on the bill, please?
I, Mr. Chair, would like to move the bill as amended.
There's a motion to move the bill favorably as amended. Is
Second.
second. Discussion on the bill as amended. Would anyone like to say anything on the bill as amended?
I'll say something.
Well, will Delegate Juanita Fisher just raise her hand, and then we'll go to the Vice Chair.
Thanks, Mr. Chair. I don't know. I guess it feels different being on Zoom when we're doing these voting sessions. I know that there's a lot in this bill. There are things that will make some people happy, make some people unhappy. I don't think anyone feels that anything's 100% perfect, but there is a lot of great work put into this bill by a lot of members of this committee and our speaker. And so I just wanted to say my appreciation for the work. And I also want to say that this is the first step, and that I don't think that police reform and accountability ends with this bill. I think this bill launches our legislature and our state to that journey that I think we will be on, not only this session, but sessions to come, so that all of our children feel safe and protected by our law enforcement, and feel that their voices are heard and that their lives do matter, because Black lives do matter. And my life and the life of other Black and brown folks do matter. And so I just wanted to say that for the record, and thank you, Mr. Chair.
Thank you very much. Recognizing the Vice Chair.
Thank you, Mr. Chair. So I wanted to say that I think this is an incredibly significant moment for our committee. I am first thankful to the Speaker for making police reform and accountability in our state a priority, and entrusting me with helping to shepherd this through. And it's not completely through, but I think getting it through our committee is a huge deal. I want to thank the chair and the Speaker's staff. And I want to thank this committee. I want to thank the work group. I think from the work group to the Public Safety Subcommittee to this committee, no matter which side of the aisle that you are on, we have had incredibly tough conversations, and we have done them in a civil and a respectful manner. And I appreciate that. We spend a significant amount of time together. And, you know, folks don't know this, we might argue and bicker, but I mentioned this earlier. I mean, we are like a family, and these are tough issues, and they're issues that are incredibly personal. And so it makes it difficult when they're personal and they affect you, to figure out what is the right thing to do no matter what side of the aisle you're on and what side of the issue you're on. So I appreciate it. I think we have done huge steps when we get this out, huge steps forward for the state in terms of, wow, what did we just do in terms of transparency records, repealing the LEOBR, making accountability measures for police here in the state, creating a new use of force standard and training for officers here, and community oversight. At each step of the process, there is packed in community oversight. So I think what we have done is incredible. So in a different meeting earlier this week, some folks said to the Speaker, the Chair, and I that the nation is watching. And I think this bill is just an incredibly transformative model for not just Maryland, but for our state. And I want to personally thank all of you, because this is the work of all of us. This is the work that we have all put into it. So thank you very much. Thank you, Mr. Chair.
Delegate Cardin.
Thank you, Mr. Chairman. I just wanted to say thank you to the Vice Chair for accepting the language that I have proposed dealing with the no-knock warrants. I really think it's going to make this bill better. So thank you very much, Delegate Adam.
Delegate Cox.
Thank you, Mr. Chair. And I also want to thank the Vice Chair for working in an attempt for bipartisan efforts on some of these portions. I understand the urgency that the Chair has expressed and the Vice Chair has expressed in terms of the need that you feel to move the bill. My concern is that we have an opportunity to do this right, and we have an opportunity to make sure that our law enforcement is not feeling like they've been hung out to dry and haven't had an opportunity to really review the bill. And I know that Mr. Chair, you held the bill over from last night, but there were significant pages, I think close to almost 10 that were added in today. And I have not been able to adequately review those along with some of my constituents. And so for that purpose, I'd be requesting a hold.
I think that we're at a point where there was a motion and a second. We've discussed the bill extensively for months. I think I know that we had a hearing on the legislation that effectively was passed from JPR, and I think that we're ready to vote today. Delegate Bartlett, then Moon, then Williams.
Thank you, Mr. Chair. And thank you, Madam Vice Chair, for your work and all of the work group members. I was not part of the work group. I was part of the Public Safety Subcommittee. And I have to say that we are not finished, but I am looking forward to the time when we are, because I think that the bill will ultimately save lives. And I am very, very proud of the work that we've done. We will have ample time to continue to work on this bill through the floor work and the any conference work. So we know we're not done, and we will have plenty of time to continue to review the bill. But I just wanted to say thank you to all of those who have worked on it and to the entire committee.
Delegate Moon.
Thank you, Mr. Chair. I'll be brief. And it's also partly a response not to allow a hold on this bill. In addition to the subcommittee meetings, the work group, the full committee conversations, the extra time we had to review the bill and submit amendments. We're at 5 o'clock now today. I will also say some of us were on this committee and this body 5 years ago when we dealt with LEOBR. And so in some ways, it's not just this last year of lessons, it's plus 5 years plus everything that came before that. So, you know, it's not a perfect product, I admit. I didn't see everything I wanted get put in here. But looking back to 2015 and the post-Freddie Gray unrest and remembering that this is not the first time we've been here, I will say that this feels like we are doing something very significant here. You know, restricting things to necessary force, the public release of misconduct records. This is stuff I really wasn't sure was going to happen in my career in Annapolis, if not in this session. So I just want to say I'm really proud of the work we did. And let's hope the Senate spends as much time as we did as we duke it out with them in conference committee. So thank you, Mr. Chair, Madam Vice Chair, and colleagues.
Delegate Williams, then Malone.
Thank you, Mr. Chair. I'm not the newest member here, but one of the newbies sort of tier to the General Assembly. And so I just wanted to say, when I ran in 2018 for this seat, I ran to be a voice for the people who didn't have a voice for themselves here in Annapolis. And little did I know that the events of 2020 would transpire after I got here to Annapolis. And so I agree with the sentiments of my colleagues. You know, I always, you know, when I was a baby lawyer, they always said, when you go to court, if the plaintiff isn't happy and the defendant isn't happy, then clearly the judge has made a good ruling. And I truly do feel like this bill is probably one of the strongest bills in the country, one of the best bills in the country that we're going to see here on this issue. As I've talked to my friends and colleagues and other state legislatures across the country, they are shocked and amazed about some of the work that we're doing here in Maryland. And I want to thank the Vice Chair for all of her hard work over the interim and just during this whole session. I just want to thank the Chair for shepherding this all along, and just everybody on this committee who has put in hours and hours of hard work and dedication to help save the lives of so many people here in Maryland. Whether we're talking about Freddie Gray, whether we were talking about Corin Gaines, whether we're talking about William Green from my own home country of Prince George's County, whose lives were lost at the hands of police officers. That's what this bill is about. And this bill is about making sure that those things do not happen again. And so I appreciate what everybody has done. And I'm proud to go to the floor and stand up for this bill and say this is the right thing for us to do here in the state of Maryland. Thank you.
Delegate Malone.
I just want to join Delegate Cox, although I'm not requesting a formal hold. I don't like the policy of making a final vote when we've had so many significant changes. These parts are interlinked, and I don't think it's wise to be voting on something when you haven't had a chance to review it in total. I just wanted to share that view.
Thank you very much. Delegate Grammer.
Thank you, Mr. Chair. I really do appreciate the efforts of everybody here. But frequently, I think election season and legislative season blend together. And we frequently whip people up in election season. We get here and I feel sometimes we're just managing politics. And I know I'm a little bit heated personally right now, but I think we're really falling short on some long-term things that need to be dealt with. And I don't want to be back here having to explain why people haven't been protected, because a lot of these issues are going to come right up again. And to have the law enforcement officers' Bill of Rights get chopped up in the middle, I'm just not very comfortable with it.
Delegate Deborah Davis.
Thank you, Mr. Chair. I'd also like to thank the committee. The thing that sticks in my mind right now are the tens and the number of mothers who came out to testify, asking for help. Their voices are ringing in my head, and I want all of you to know that they've come out year after year after year, and they've gone through the trauma of retelling their stories over and over. And today we have shown that we listened. So to that, hats off to all my colleagues. We listened, and I'm sure they are resting more comfortably today, even though they lost people dear to them. I know that they're resting more comfortably because somebody listened. Thank you.
Delegate Ron Watson.
Thank you, Mr. Chair, and hopefully I'm the last person, but I do want to say this, although I'm not the newest member to this subject matter, I have tried over my life to stay as far away from the police as possible. And I will tell you, I'm very appreciative and deeply thankful for the ability to be able to reach out, receive the phone calls, and try as best we can to work towards a win-win scenario. I recognize, and I've told folks, that a bill of this magnitude will rarely be 100% right out the gate. I'm sure we'll look at some pieces next session as we move forward. We may see some things that there was, we needed a little more oversight on, and it'll give us the opportunity to enhance what we already have. I do want to thank the chair and the vice chair. I appreciate your leadership. I appreciate your ability to work those long hours, but most importantly, for somebody like myself who does not have a legal background, I appreciate your ability to distill for us the nuances of law, of policing, to try to put together a package. And although she's not here, I also wanted to thank the speaker for her leadership and her support throughout this process. I just want to say thank you. I appreciate everybody's input on this committee. We don't always agree, but we always agree that we work together to try our best to do the right thing. So thank you, everyone.
All right. Are there further questions or further comments? Delegate Davis is waving her hand. Delegate Davis is muted. Delegate Davis, you're muted.
I believe we skipped over the training amendment.
I think we have just discovered that too. There is an amendment that where is the amendment? One moment, please.
I apologize.
No, it's fine. All right, Delegate Davis, the committee, there was an amendment here that appears that I think had been discussed, that we may have even discussed yesterday, that for some reason is not on the list here. And I'm going to ask, and we're trying to figure out why we've got a technical issue with this amendment. Delegate Davis, would you please describe what that amendment does?
You're going to have to put it up.
One moment. All right. Delegate Davis, is this the amendment that deals with training? Because it's dated February 23rd, 2021. I don't believe that this is the amendment that deals with training. Delegate Davis, do you have a copy of the amendment that you're talking about there?
I do not have a copy.
That's what she sent. All right. Put it back on the screen. Delegate Davis, would you describe what the amendment does?
Okay, thank you. Whew.
All right, I also understand that council may have the amendment. Is council available to describe what the amendment does?
Okay. This amendment deals with excessive force by law enforcement officers. It adds a new subtitle to the Courts and Judicial Proceedings article, which authorizes a person to file a civil action for use of force by a law enforcement officer.
Council, one moment. Does this amendment have to do with training related to the use of force? This is not the amendment that Delegate Davis was talking about.
This was I'm sorry, this was an amendment I was provided with yesterday. So I assume this was the right one.
So
my
understanding, Delegate Davis, is that you had an amendment, and I have a list. I have this here that says that it is about use of force and training related to the use of force. Is that correct? She has mouthed the word yes.
Yes.
Okay. Here's what we're going to do. One moment, I need to hear from staff. Hold on one.
Mr. Chairman, I believe I found it and I have forwarded that to Dylan.
All right. He's going to pull it up here shortly. One moment. All right, Delegate Davis, there is an amendment on the screen.
I'll give a summary, Mr. Chair. The amendment intends to establish a minimum standard for internal use of force policies, and it requires the Police Training and Standards Commission to develop uniform guidelines for law enforcement agencies, and it outlines what they are. We're going to give a lot of authority to the Police Training and Standards Commission. So I think it's important that we give some baseline training requirements and include it in the bill.
Why can't I? There it is.
Mr. Chair?
Yes, Vice Chair.
Thank you, Mr. Chair. Everyone should have just received it in their inbox if you want to pull it up in your email.
Is it sent to everyone in the committee?
Yes.
Excuse me, was it sent to our floor or our public email?
I believe your public email.
One moment. All right, Dylan is about to send it to everyone, and it'll take a moment here, and we will send it out to everybody.
Mr. Chair, can we ask a question in the meantime?
Let's do that. Delegate Griffith to begin, then Delegate Fisher.
Mr. Chairman, this is a procedural question. Are we still on the previous question on the bill as amended?
So at the moment, we are on the bill as amended, and there was a motion and a second. So if we're going to go back, we need to go back to consider a further amendment. And so I would entertain a motion to go back again to the bill to consider the amendments.
Mr. Chair, do we have to vote on the previous? And this is a Robert's Rules question I don't understand. Do we have to, since we have a first and a second, do we have to vote on the previous question to go back, or can we suspend the question we're on?
I can withdraw my motion.
Yeah, that's
So
what I was going to ask.
the vice chair is going to withdraw her motion.
Thank you.
The training requirement on use of force, I think, was something that the subcommittee had discussed, and that I believe we as a group had discussed last night. So we'll go with that. Delegate Juanita Fisher.
Thanks, Mr. Chair. I just had a question and this could be, I guess, for council or for Delegate Davis. So the training would be set up by the commission in order for individual departments to do. This would require it. Would it have a penalty for them not doing this training, or it's just sort of like a best practices training on use of force? Do you know what I mean?
I don't know exactly what Delegate Davis intends with this particular amendment, but the bill already does require, the Maryland Police Training and Standards Commission already is required to provide training to all officers in use of force. And the bill,
so this is just like lining up each type of thing they have to do. I understand now.
Absolutely. And what's also important is that it outlines definitions, which I thought was really important.
Okay, I see that. I'm looking at it on my screen. I see that now. Thank you. I'm sorry about that. Thank you, Mr. Chair.
Delegate McComas, then Grammer.
Mr. Chair, I just have a procedural question, and maybe it was my understanding everybody had to have the stuff in amendment form, and I don't see that this went through the amendment office. I'm just asking a question. I mean, maybe we're, being a little, but I know everybody that was putting in amendments, they scrambled around to make sure they'd gone through the amendment office. And this one is pretty significant and extensive. And I just wondered if, well, maybe we didn't need to run through the amendment office. Just
I appreciate that. And Delegate Davis has provided this in writing. It for whatever reason was not placed with the other amendments that went out from the committee, and for that we apologize.
Yes.
Grammer.
I just want to make sure what we're looking at is just item B, the de-escalation tactics. That's the amendment, not the whole document. Is that correct?
I still don't have the document. Could Dylan send it to my floor laptop, please?
and to my law office email, please.
And I guess that would be a question for Deb or the chair. What we're just talking about is in section 2, item B, right?
I think that goes to the use of force standard, which is already in the bill. And the bill already requires on page 17 that the commission provide training in the proper level and use of force as set forth in the Maryland Use of Force statute under 3523 of this title. And that training has to be provided to officers initially when they become police officers and in service every 2 years.
Understood.
So-
Said more
I
clearly.
don't-
Said more clearly. Are we voting on this whole document or just what's in bold?
What's in bold is not really about training. That's for under the use of force policy that's already in the bill.
I hate to complicate this, but what are we voting on here? And I'm not trying to be facetious. I just want to make sure.
No, I understand that. All right, this is what we're going to do. This is what we're going to do. I'm going to say to the committee, I'm going to kind of ask for the committee and say that we're not going to take this amendment up tonight. What I'm going to recommend is that we move the bill. This committee will be having a voting session on other legislation on Monday morning at 11 a.m. We can address this issue at the voting session at 11 on Monday and decide whether or not to take Delegate Davis's amendment at that time. What I would ask for now is a motion on the bill as amended presently. And then the committee can decide whether or not to do a further committee amendment with Delegate Davis on Monday.
I move the bill as presently amended, Mr. Chair.
Moving the bill as presently amended. Is there a second?
Second.
Is it amendment bill? Move for a favorable and a second. We have had discussion. Seeing no further discussion, we will have a roll call. The Vice Chair,
Yes.
Delegate Ericon,
No.
Delegate Bartlett.
I think you skipped me.
Delegate Bartlett. I know what I did. Delegate Bartlett.
Yes.
Delegate Carden.
Yes.
Delegate Conaway.
Yes.
Delegate Cox.
No.
Delegate Crutchfield.
Yes.
Delegate Davis.
Yes.
Delegate Fisher.
Yes, Mr. Chair.
Delegate Grammer.
No.
Delegate Griffith.
No.
Delegate Jones.
Yes.
Delegate Lopez.
Yes.
Delegate Malone.
No.
Delegate McComas.
No.
Delegate Moon.
Yes.
Delegate Shetty.
Yes.
Delegate Cham.
No.
Delegate Watson.
Yes.
Delegate Williams.
Yes.
The good delegate from the 43rd District of the great state of Maryland, Delegate Kurt Anderson.
Yes.
The favorable motion passes. All right, we will have a voting session on Monday at 11 o'clock. There will be a bill list printed. We will also take up a potential committee amendment for this bill, House Bill 670, along with those bills. Thank you for watching us this evening. Thank you to the committee, and we are adjourned.